Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence Online. Tonight's chapter lecture is going to be on Chapter 9 Hearsay and its exceptions. Now, because of the complexity of hearsay and the number of exceptions to the hearsay rule, I would strongly urge all of you to look at those key definitions and look at the discussion questions. But most importantly, go through and look at the examples that are listed in the textbook underneath the definitions and some of the subjects that we're going to talk about, because again, those examples are going to help you get some context to the lecture. And this one's going to be a little bit confusing, kind of. So I'm going to hope to make it easy and clear, but sometimes things aren't always as easy as we want them to be. So with that being said, let's dive into Chapter 9. So our case study is going to be on this gentleman named Drew Peterson. Now, in 2012, Drew Peterson went on trial for killing his wife, Kathleen Peterson. And the physical evidence was split between homicide and accidental death. So meaning that there was enough evidence to say it was a homicide and enough to kind of say it was accidental death. So kind of a lot on each side. Now, numerous witnesses, however, repeated incriminating conversations that they had with the deceased involving Peterson's threats against the victim. And based on this testimony, Peterson was subsequently convicted. Now, excuse me, some parties who testified against Peterson had motives to lie about what the deceased had said. So how can we know when a witness is repeating what they hear accurately? And when does repeated conversations become too untrustworthy to admit into evidence? And if witnesses couldn't repeat Kathleen's words, then who would actually speak for her? So an interesting case, you guys, and I would suggest that you would take the time to watch it, because there are a lot of things, specifically testimony, and a lot of the exceptions, if you will, to the hearsay rule that you're going to see and hear in this particular case. So with that being said, let's talk about what we hope to take away from tonight's lecture. Well, we hope to be able to explain what is and what is not hearsay, and understand what exceptions exist to the hearsay rule, including things like former testimony or dying declarations or confessions or statements made against interest. And then we hope to understand how to be able to explain how impeachment interacts with hearsay. So those are our learning objectives. So just a few things as we start. People frequently misuse the term hearsay. And this makes it very important that you understand the term in its legal context. Now, this is a great picture, if you will, that shows the exceptions to hearsay. And this is why I suggest that you utilize the resources in the textbook, and especially look at the examples that are listed under each of the exceptions and all the other areas in the textbook, because of the complexity of all of the exceptions. And you can't possibly memorize all of this stuff. So again, I'm going to hit on the broader points, if you will, and hopefully that will be sufficient to make you understand hearsay a little bit better. So here is what hearsay is defined in the dictionary. So hearsay, as defined, can mean rumor, And synonyms to rumor would be like buzz or gossip or scuttlebutt or talk. And it also means something you heard from another person or something that you've been told. So our legal system usually requires that a case be decided solely on the basis of sworn testimony given in the presence of a trial judge or jury. And the general rule is that that out-of-court statements may not be used as evidence unless they fall under one of the exceptions to the hearsay rule. And this chapter defines hearsay. And it also briefly discusses 12 of the most common exceptions to the rule. So some myths and some facts. Well, a myth that, a person cannot be convicted based on hearsay. Well, a conviction can be based on any type of admissible evidence, even hearsay, because remember, there are exceptions to the hearsay rule. And then another one would be hearsay only applies to what people say. Well, hearsay applies to both oral and written statements. And hearsay only applies to what other people say. Well, hearsay applies to what everybody says when they are not under oath. So let's kind of get into the lecture and try to define things a little bit better. So, as I stated before, people frequently misuse the word hearsay, which means that this makes it very important for you to understand the term in its legal context. And the definition in the Federal Rules of Evidence, which I'm going to talk about in a second, has been adopted by approximately half of the 50 states. So to understand the hearsay rule, start by considering three different things. What is a statement? Who is a declarant? And what is meant by the phrase offered in evidence to prove the truth of the matter asserted? And we'll talk about that. So the general rule, again, is that out-of-court statements may not be used as evidence unless they fall under one of the exceptions to the hearsay rule. And you can actually click on this link down here if you want to know what defines hearsay and some of the exceptions. And hearsay is an out-of-court statement made by the declarant. That's the party who made the statement in the past, and being offered to show the content of the statement is true. And this statement can be oral, written, recorded, and even body language. So statements are hearsay if they are not made in court, in essence. So again, let's look at these three pieces that I just mentioned a second ago. A statement may include several types of communication: oral, written, recorded, audio, or videotape, or digitally, or nonverbal. In fact, anything a person says is a statement. So are his letters and business records, the deed to his or her house, and similar. However, technically, the word statement is much broader, and it even includes things like body movements done with the intent to communicate. And specifically, it includes actions such as shaking your head, like no, or pointing in answer to a question, like which way did they go, and you point a certain way. And statements are hearsay if they were not made in court under oath at the hearing or trial that is currently being conducted. The common idea that what you say is hearsay but what I say is not really correct. Statements originally made by a person while that person is not testifying in court are hearsay. And this means that even the sworn testimony of the witness that was given at the preliminary hearing is hearsay when offered at a subsequent trial. Now, don't panic. There's a lot of exceptions. And the witness's account of what he or she said while the crime was being committed is also hearsay. So I know, again, this is a lot to kind of to swallow at one time. So now we know what a statement is. So remember, we're back up looking at like statement, declarant, and then that phrase offered in evidence to prove the truth of the matter. So again, what's the declarant, or who is that? Well, the declarant is the person who made the statement. And if the witness is telling what he or she learned or heard from someone else, or what someone else said, the person who originally made the statement is the declarant, and that statement is hearsay. If the person on the witness stand is telling what he or she previously said, the witness is the declarant, and the statement is also hearsay. It is important to determine who the declarant is, because the facts surrounding the declarant's statement are considered when determining if one of these exceptions to the hearsay rule actually applies. So again, stay with me, it's tough. Now, something is offered to prove the truth of the matter asserted when the attorney wants the jury to believe the answer. And most testimony is admitted for this particular purpose. Now, in the Drew Peterson case, Kathleen's statements are hearsay. They were offered to prove that Drew had threatened to kill her. Now, sometimes, however, an attorney will ask a question for some other reason, such as to show that the person was, hallucinating or something like that. But again, we kind of know now when we're talking about offered to prove the truth of the matter asserted. So hang in there. You're doing pretty good. So let's look at a couple of examples before we move on, and maybe this will kind of help. And then don't forget, there's examples in your book. So when we talked about examples, on page 246, examples of statements that are hearsay and examples of statements that are not hearsay. So each one of these key topic areas we cover, your textbook gives you written examples to look at to help you get a better understanding on what that topic really means. Does that make sense to everybody, hopefully? Okay, so the prosecutor asks a police officer to tell the jury what the defendant said during an interrogation. And this is offered to show the truth of the matter asserted, that the defendant committed the crime as described in the confession. It is hearsay. Now, there's a little comment down at the bottom, and you can kind of disregard that. I used this particular slide in another class, and I had a very interesting interview of a suspect that I had them watch, and then we put this up as an example. And I may actually post that interview as well. But let's just stick to the main text of the slide, if you will. So here's an example of like not hearsay. So that was one that is. So the prosecutor asks the witness to repeat the defendant's original alibi, even though the defendant later changed her alibi. Now, the purpose of this is to show that the defendant is a liar, not to show that the original alibi was true. So when you use it for this purpose, the original alibi is not hearsay. And you're probably going, oh my gosh, your hands are over your face and you're trying to figure out, I just don't understand. It's okay. Hang in there and we'll get to it all. So when you talk about the hearsay rule, hearsay is not admissible in court, and we've kind of gone over that. Now, again, there are many exceptions to this rule that are discussed later on. And statements are admissible in court if they fall under one or more of those exceptions to the hearsay rule. And many hearsay statements were in fact admitted or allowed in that Drew Peterson case. And when you watch it, hopefully you'll see that. Now, there are several reasons for the hearsay rule. And what do you think, why hearsay is really not admissible? Why shouldn't it be? Well, I mean, let's kind of look at a couple things. Well, the first could be that the party could lie about the content or recollection. So, giving false testimony, let me back up. The most important of these reasons would be the thing that I just went over with you, which is a basic distrust of testimony that was not made under oath. And giving false testimony while under oath can be prosecuted as perjury. So, since the hearsay statement was made without any fear of prosecution or perjury, it is not considered as trustworthy as statements that were made under oath. So thus the reason for under oath. Does that kind of make sense? So one of the reasons why hearsay is not admissible is because people could lie about the content. Another reason courts are suspicious of hearsay is that the jury did not see the person while he or she was making that hearsay statement. And demeanor, remember, juries can use demeanor. They can draw an inference from demeanor. So demeanor provides many clues that help jurors decide if the witness is credible or telling the truth. And all of those clues are missing if the jury is not able to watch the person make the statement. Now, the fact that the person who originally made the statement is not testifying at trial also means that the defense attorney will not be able to cross-examine that person. And cross-examination is key to determining whether a witness is telling the truth, right? Whether it's the prosecution or the defense doing the cross-examination. The defense can question the person who testified to make sure he or she is accurately repeating what was said, but that's kind of a weak substitute. So for all these reasons, hearsay is kind of distrusted. So remember, anything not given under oath is not really as trustworthy. And why? Would be for the reasons that I said. False testimony under oath can result in perjury. So why would hearsay not be admissible? Well, let's look at a couple reasons perhaps why hearsay wouldn't be admissible. And some of them we kind of went over. Remember, the party testifying could misinterpret what was said. We talked about how the jury can't see the demeanor of the person testifying. That's kind of, why it's important. The defendant loses the right to cross-examine. Well, under the Sixth Amendment, you have that right. And speaking of the Sixth Amendment, where does that fit into this whole conversation? But again, don't panic. Many exceptions are there. So let's look how this weaves. The Sixth Amendment kind of comes into play. So if you remember the Sixth Amendment, you should know that there's a couple of parts. And the confrontation clause of the Sixth Amendment to the United States Constitution gives the defense in a criminal trial the right to confront and cross-examine the people who accuse the defendant of a crime. And that includes the right to confront the people who told the police they saw the defendant commit the crime. So when hearsay is improperly used at trial, the Sixth Amendment confrontation clause is actually violated. And therefore judges are very cautious, because erroneous rulings that allow the prosecution to admit hearsay have the potential for causing the conviction to be reversed due to a violation of someone's constitutional rights. And if you look here at the Sixth Amendment, and I have a YouTube video of a really cool guy that talks about the Sixth Amendment, you can look at that. You can see right here in bold, to be confronted with the witnesses against him. This is part of the Sixth Amendment. So you can see how the Sixth Amendment plays this big role. Now, despite the fact that there are very good arguments for not admitting hearsay into evidence, there are some situations in which out-of-court statements obviously should be used. And these situations are the basis for the exceptions to the hearsay rule. So hopefully that kind of helps shed a little bit of clarity there. And an exception to the hearsay rule used during criminal trials must be based on the source of the statement being trustworthy. And some exceptions are based on necessity, such as dying declaration of a murder victim. And even so, these statements must be trustworthy. Other exceptions to the hearsay rule, are based on the concept of, fair play. And for example, it would be unfair to exclude the defendant's confession solely, meaning just that one thing, because it was not made under oath. It would also be unfair to allow one side to introduce an edited version of an out-of-court statement, but deny the opposing side the right to introduce the portions of that statement that were intentionally left out. So again, there's reasons for the exceptions, and some of them are on necessity, and some are just because, it really amounts to the concept of fair play. So let's move into this terminology now called testimonial hearsay. In Crawford versus Washington, a case in 2004, and Davis versus Washington, a case in 2006, the Supreme Court ruled that the prosecution can use testimonial hearsay at trial only if the person who made the hearsay statement testifies. And bear with me, so this is going to be a little confusing, but I'm going to try to make it simple. So in Davis, that case in 2006, the court explained its holdings like as follows, and I'll read it quickly. A critical portion of this holding, and the portion central to the resolution of the two cases is now before us, is the phrase testimonial statements. Only statements of this sort cause the declarant to be a witness within the meaning of the confrontation clause. It is the testimonial character of the statement that separates it from other hearsay that, while subject to traditional limitations upon hearsay evidence, is not subject to the confrontation clause. statements are non-testimonial when they are made in the course of police interrogation under circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. They are testimonial when the circumstances objectively indicate that there is no such ongoing emergency and that the primary purpose of the interrogation is to establish or prove past events potentially relevant to the later criminal prosecution. Well, what does that mean to those two cases? Well, both cases considered by the Supreme Court in Davis were domestic violence cases. Now, in the first one, portions of the 911 tape were played for the jurors. And the distraught woman could be heard telling the operator that she had been hit and the assailant was leaving. Now, the court ruled that this was non-testimonial because the intent was to obtain police assistance during an emergency, just like we talked about in those two cases. Now, in the second case, police officers responding to a domestic disturbance found the victim alone on the front porch. She appeared somewhat frightened, but told the police that nothing really happened and nothing was the matter. And the officers separated the parties and talked to them, and after hearing the wife's account, the officers asked her to fill out and sign a battery affidavit. And her handwritten affidavit said something like, broke our furnace, shoved me down on the floor into broken glass, hit me in the chest, threw me down, broke our lamps and phone. Now, emphasizing that the emergency no longer existed because the person was gone and she was alone on the porch, the court ruled that the affidavit was testimonial hearsay and should not have been used at trial because the person who made it did not appear in court. Now, in the aftermath of that particular case, and that was the Crawford case, there were some things that made the domestic violence issues relating to hearsay a little bit more clear, but the court still held its ground on its ruling. So you can kind of say, you know, things like 911 tapes are not testimonial hearsay. Well, then what about DNA lab reports? What about a lab report? So I send DNA in and I get the report back. Is that hearsay? Well, let's talk about it. And here's the Crawford versus Washington case that you can take a look at it, but I pretty much covered it for you. So lab results, let's cover that one before we move on to this unavailable declarant. So lab reports, you're going to probably think this is crazy, are hearsay and subject to the confrontation clause. And you'll probably understand why in a second. In a series of recent cases, Melendez-Diaz versus Massachusetts in 2009, Briscoe versus Virginia in 2010, and I think it was Bullcoming versus New Mexico in 2011. I believe that was it. The Supreme Court made it clear that the person who conducted the test must testify in court. DNA analysis was involved in the Williams versus Illinois case in 2012. And the police sent a DNA sample to a private lab, which prepared a DNA report and a profile. And the profile was then matched with the one in the state's database. The DNA analyst from the state's lab testified about matching the two profiles, but you know what? No one from the private lab testified. But the Supreme Court held that this procedure did not violate the defendant's rights. So, I mean, again, this is very technical, and you might think you have a pretty good handle on it, and I hope you do. But just look at the the larger portions of the subject matter. Don't try to drill down too deep because it can get a little bit confusing. So let's move on. Well, what happens if somebody's not available? How can you get them into court to testify? Because we know that people may have to come testify in order to add validity to a statement or make it, unless there's an exception to the hearsay rule, they're going to have to show up and testify. Well, I think the court looked at some of those issues, and here's what we have. So several exceptions to the hearsay rule are based on the declarant being unavailable or the unavailable witness. And if the declarant is alive, the attorney who wants to introduce the statement is expected to conduct a thorough search for the witness and subpoena him or her to appear in court. And this is what is referred to as exercising due diligence, doing the best you can, in this case, to find someone. Now, the judge will not declare a witness unavailable if it appears that the side that wants to introduce the hearsay evidence failed to use this due diligence to find the person. So if you just decided, hey, I can't find them, but I didn't look, the judge isn't going to go for that. So unavailability is a requirement under 3 hearsay exceptions discussed a little more in this chapter. And one would be declaration against interest. Another would be dying declaration. And another one would be former testimony. And if you look at the federal rules of evidence under section 804A, you can see the definition or what defines unavailable. And we're going to talk about a few of those in just a second. So the federal rules of evidence provide us a list, the things I just showed you, of 5 situations that are considered sufficient reasons to allow non-testimonial hearsay to be used in court, even though the declarant could not be found. And most states will accept similar reasons when no testimonial hearsay is involved. And the judge will require proof that one of these circumstances actually applies. So a declarant is considered to be unavailable as a witness when is exempted from testifying about the subject matter because the declarant's statement or the court rules that a certain privilege applies, refuses to testify about the subject matter despite a court order to do so, lack of memory, so testifies to not remembering the subject, unable because of death, mental illness, or infirmity, or sickness, so the person can't be present or testify at trial or hearing because of death or sickness or physical illness or mental illness, and is absent and unable to locate or procure the witness. So those are those 5 situations. All right, so continuing on. So now we've talked about declarant unavailable. And here's the case of Davis versus Washington, the one that I talked about on the domestic violence case. So I'll let you look at this one, and there's even a link at the bottom to a case summary. And here's the Melendez-Diaz case. So Mr. Melendez-Diaz was charged with various narcotic violations for possession of cocaine. And the prosecution introduced a forensic lab report confirming the substance seized was cocaine. But they didn't call, remember, the technician who did the work. They only provided a certificate of analysis. And because of that, the court threw out the conviction, stating that it is required that the defendant have the right to confront a witness testifying against him. And that would have been the lab technician that actually did the analysis of the drug. So I think that kind of helps add some context to what we're talking about. So let's kind of skip by the questions on this one because we have so much information. So let's try kind of a new one and see how we do with this. Using the Drew Peterson case, and you'll have to watch it to kind of get context to the question, or I think just what's written in the textbook might give you enough. When Anna testified about what her sister Kathleen said, Kathleen's statement would be what? Well, that would be hearsay, right? Because you're testifying about what somebody else said. Well, let's try another one. When Anna testified about what Kathleen told her that Drew said, Anna's testimony about what Drew said would be what? So let's read it again. When Anna testified about what Kathleen told her that Drew said, Anna's testimony about what Drew said would be what? Well, you have a cool thing called double hearsay. So let's talk a little bit about that before we kind of move on. So remember, only statements that fall under one of the exceptions to the hearsay rule are admissible in court. And when prosecutors, again, when they review a case to decide if there's enough evidence to convict, one of the things they're really looking for are statements that fit within the exceptions to that hearsay rule. Now, several other points should be kept in mind. And one of them is that hearsay varies greatly. Some are so convincing they constitute key evidence in the case, and other statements are kind of frivolous. And finding the appropriate hearsay exception so as to get certain evidence admitted merely ensures that the jury is going to hear it. And again, the jury is going to decide how much weight to give the evidence or that testimony. Now, in some situations, more than one exception will apply. And examination of the requirement for the various exceptions may reveal technical reasons why one will be more appropriate to use than perhaps another. And then sometimes, as we did in the example, we come upon what is like double hearsay, which is hearsay embedded in another hearsay statement. So again, if we look at this one, Anna's testifying about what Kathleen told her about what Drew said. So she's not testifying about what Kathleen said. She's testifying about what Kathleen said about somebody else. So this, in fact, would be what we call double hearsay. Now, out-of-court statements made by the defendant appear to be within the definition of hearsay and are treated that way by some states. Now, the federal rules of evidence declare that statements made by parties to the lawsuit are not hearsay, thus avoiding the need to create an exception to the hearsay rule in order to use them at trial. So let's kind of take a look at admissions and confessions. An admission of a party and used at trial against them. So we know the federal rules state that this is not hearsay. As I just said, and most states claim it is hearsay but grant an exception. And then the practical application would be admission of party or confession, adopted by him, an agreed statement, authorized by him, order or directed, and made by an agent with authority. Well, what about like co-conspirators? You know, two people conspire to commit a crime. How does that all fit in? Well, many states allow this particular exception, and the statements must be, of course, within the scope of the conspiracy and in furtherance of the purpose of the conspiracy. Now, if you look on page 255 and 256, you can see some examples. But again, many states have a hearsay exception for admissions by co-conspirators. And this rule closely mirrors the criminal law rule that makes each conspirator responsible for acts of other conspirators. And statements made by one conspirator during the conspiracy can be used against another conspirator. And the statement must be made within that scope of the conspiracy and in furtherance of the purpose of the conspiracy. Well, now we're going to talk about, like, well, what if it's something unique, like a spontaneous statement? And this kind of falls under the realm of a statement made after and about a startling event. And you can find this in the FRE under section 803. And some states consider present tense impressions, spontaneous statements, and contemporaneous declarations to be three separate exceptions to the hearsay rule. And other states include them in what they call the res geste, which means things done exception to the hearsay rule, that covers a variety of statements to explain the actions that were being done at the time the statement was made. So these exceptions to the hearsay rule are considered to be trustworthy. And the reason is because there wasn't typically, there's no time for the declarant to think about what he or she is saying. And unlike a statement that is composed in order to present the case in a mannerable favor to the declarant, the speed with which the spontaneous statement or contemporaneous declaration is made is believed to lower the probability that the declarant is lying. So again, the statement must relate to the event. When you're talking about spontaneous statements or this excited utterance, it's a statement made after and about a startling event, and it has to be relative to the event that's happening, not something else. And it has to be made under stress or excitement. And it's considered trustworthy because there's no time for the declarant to kind of sit there and think about what he or she is actually saying. And sometimes the defendant in a criminal case makes a statement that would fall into the category of simultaneous statement, or what they call contemporaneous declaration. And these exceptions to the hearsay rule are rarely used in these circumstances because it's easier to have the defendant's statement admitted under the admissions exception. So review, and we'll look at these questions probably later. To qualify as a spontaneous statement, the declarant must have personally observed the event he or she is commenting about. And this includes the utilization of any of the five senses, although eyesight and hearing are probably the most common. And given the current level of live broadcast by the media, it's no longer necessary for the declarant to be actually at the location where the event occurred. And the statement must be made very, very near or time-wise to the occurrence of the event in question. The person should still be responding to the event, or as some codes state, in the excitement of the moment, if you will. And the length of this interview will vary with the type of stimulus involved. The stronger the stimulus, the longer the excitement of the moment is likely to last. And in some cases, this rule is applied to the time immediately following being told of an event, such as the death of a loved one. Now, in the Peterson case, if we look at that one, Kathleen told her friends how frightened she was when Drew threatened her and held her down. But these statements, think about it, they don't qualify as excited utterances or spontaneous statements because of the time lapse between the event and when Kathleen told her friends about the incident. So hopefully that kind of brings or sheds some light on the subject of like spontaneous statements, etc. So contemporaneous declarations, or the present sense impression, if you will. For something to be admissible under the contemporaneous declaration exception to the hearsay rule, the statement and the acts must occur at the same time. Thus the word contemporaneous, which kind of means at the same time. And they have to relate to the same event. Now, there is no requirement that the statement be made spontaneously. The statement will be admissible even if they are in response to a police officer's question, such as, hey, what are you doing? And additional questions about what the person is doing, thinking, or feeling as that situation evolves. So the contemporaneous declaration exception covers a person's, current medical problems, or attempts to explain the location of pain, or describing the type of pain that they're feeling, etc. That's another thing that would probably fall underneath that. So I don't want to drill down too deep and confuse everyone. So what about the dying declaration? Now, the dying declaration is one of the oldest exceptions to the hearsay rule. And it was based on the assumption that a person would not go to meet his or her maker, if you will, with a lie upon his or her lips. And yeah, I know that sounds kind of corny, but listen. Hence, it was considered trustworthy. And obviously, not everyone is reluctant to use falsehoods at the moment of death, but again, the old assumption is still used to justify admitting the dying declaration in court. And the traditional rule only allowed the use of dying declarations in criminal prosecutions of the declarant's killer. Many states now allow dying declarations to be admitted into evidence in both criminal and civil trials. And the federal rules of evidence and a few states allow the statement to be used even if the person doesn't die. So when you look about it, the statement concerning cause of impending death, so when somebody says what they're going to say regarding the actual incident that's taking place, they have to be in a position in their mind that they believe that their death is impending. And some states have added the requirement that they actually have to die, but that's not the case in many, many states. So this statement that I'm going to say in just a second, is an example of something that cannot be used as a dying declaration. So the statement of, I want to confess to the bank robbery I committed last week, indicates that the statement is not about the cause of death. Like, oh, Johnny shot me. Or I think I'm going to die. Why did Bill do this to me? That shows impending death versus, hey, I just want to confess to a robbery. So again, one of the key admissibility issues of dying declarations is that the declarant believes that he or she will die almost immediately. And if the declarant has any hope of recovery, the statement will not fall underneath that exception. So dying declarations can only be about the events surrounding the death. And again, usually it's a statement about the victim. Usually a statement by the victim about who inflicted the fatal injury. And statements about past crimes, like I said, or other things are not admissible unless that state has expanded the rule. And that declarant must speak from personal knowledge about the things he heard, seen, smelled, and so on. Now remember, some states say you have to actually die, and some states say that you don't have to. And here's a really cool video. We're not going to have time, and if we do have time, it's about 5 minutes or so. I'll come back to it because it's a great dying declaration video. So if I have a moment, I will come back to it. So examples. The victim said, I'm going to die. That jerk Peter shot me. The victim said, get a priest. I need my last rites. John shot me because we had an argument over a bank robbery money. And sorry, that's a typo. So those would be good dying declarations, yes? Now, what about a domestic violence victim that says, he tried to kill me, I'm going to divorce him? Does that show that the person believes that they're going to die immediately? I'm hoping that you're shaking your head no. Or the victim said, I know I'm dying. And this one's a little kind of confusing. I know I'm dying, but I want to confess to the bank robbery I committed last week and get it off my chest. What's wrong with that last one? Well, it's the first part about imminent death is probably there, but what's another thing that needs to be there for a dying declaration? It has to be about the events surrounding the death. Remember that part, okay? So in the Drew Peterson case, Kathleen made a number of statements indicating that she was afraid Drew would kill her. Now, none of those statements would actually qualify as a dying declaration because she did not have a sense of when she made them. So the time frame was too far apart, if you will. That imminent death, remember? And then finally, we'll talk about mental or physical state. And again, these are all some exceptions here. So the mental or physical state exception to the hearsay rule is used to introduce statements made about mental, emotional, or physical states. And the statement must relate to the declarant's mental, emotional, or physical state at the time the statement was made. Now, in the Drew Peterson case, 3 witnesses, Anna Doman, Kristen Anderson, and Mary Parks, testified about statements that Kathleen made indicating that she feared that Drew would harm her. Now, under this, all of these statements establish her mental state, and the jury might use them as the basis for an inference that Drew had in fact expressed intent to kill her. So you can see how it kind of works. So the exception to the hearsay rule here, or useful to show like intent or plan or motive or emotion or pain or state of health. And we kind of just talked about that just a second ago. Well, what about reputation? Can that be something to even think about? Well, reputation is what others say about someone. It is by its very nature hearsay. In fact, it is frequently nothing but gossip. Nonetheless, historically, there have been hearsay, or there has been a hearsay exception for reputation. Now, the terminology used is that of a character witness that is called to testify about a person's reputation. And under the traditional rule, the character witness is not allowed to give his or her personal opinion about the person whose reputation is in question, but should report on what the person's associates or the community thinks. And associates are the people who work with the person in question, and community refers to either the residential or social community. So, limited admissibility until character is raised by the defendant, and then covers reputation of defendant, witnesses, and victims. And then former testimony. The former testimony exception to the hearsay rule covers testimony taken under oath at a prior court appearance or legislatively authorized proceeding like a deposition or an arbitration proceeding. And this is one of the easiest exceptions to the hearsay rule to justify. The statement under these circumstances are typically made under oath and recorded verbatim. Therefore, it really is in fact considered trustworthy. So we look at prior statements, and then I think we're done. Prior inconsistent statements under federal law, and many states, say they're not hearsay and they can be used to impeach a witness. And consistent statements used on redirect to bolster credibility of impeached witnesses, and not considered hearsay in federal court. And I think we're just about there. I'm not going to ask these questions about ancient documents. So we're just about at 60 minutes. So I'll have you go back and watch that Law and Order video about hearsay. I think you'll get a clear understanding of the dying declaration part if you go back and watch that. And that'll show you the exception, because remember we talked about the example of the person that wanted to confess to a robbery, and while they still thought they were dying, it wasn't relevant to the actual incident or crime that was taking place, so that would not fall underneath that exception. So that's hearsay, and that's a lot of information. So if you have any questions, please feel free to post them on the discussion board. If you don't want to put them there, the general question discussion board, send me an email, and I'd be happy to answer them as well. Don't forget about the resources that are in the textbook, including all of the examples that are listed within the textbook. Those are great things to look at to help you add context. So with that, until next time.